with the technical aspects of hearings and conferences and sessions over Zoom and other virtual conferencing softwares.
Changed.
But without further ado, thank you all of our attendees, and I'd like to ask our first panelist, Mr. Siddharth Luthra, Senior Advocate and former Additional Solicitor General, to address us on this topic. Mr. Luthra, thank you for joining us, and over to you.
Good evening, everyone. Mr. Khurshid, Zafar, the other organizers. Thank you so much for this opportunity. What makes it more special is that I have the privilege of being here on a panel where Mr. Khurshid, who is, I will not call him an elder because he's ever young, but he is definitely a senior colleague and a mentor to me. He has mentored me, and a lot of what I have done or achieved in my career, not that I've achieved that much, is all because of his guidance and his support over the last many, many decades, not just last decade, but many, many decades. I'm going to speak to you about a topic, about an issue which I'm very passionate about, and that is the law of sedition. Because the problem that we face with sedition is it's a colonial artifact which continues in Indian law. In 84, Lord Denning says in England, it is now an obsolescent law. It used to be defined as words intended to stir up violence, disorder by promoting feelings, ill will or hostility between different classes of His Majesty's subject. But this definition was found to be too wide. It would restrict too much the full and free discussion of public affair. So it has fallen into disuse for nearly 150 years ago. In India, that's not the position. Sedition is going strong, it's active, its application is great, it is non-bailable, non-compoundable, and there are other offenses also. For example, promoting enmity, 153A, imputations, assertions prejudicial to national integration, acts intending to outrage religious feelings, and statements or creating or promoting enmity. Now let's go back historically. The trial of Socrates, 300 BC. Socrates is tried because he wanted youth to ask for reasons, to question everything. He's put to trials because he's corrupting the youth. Today, of course, the youth don't need corrupting. They are the ones who are leading the debate and the discussion of openness. Socrates repels the charges. He's asked to be killed by giving him hemlock to drink, drinking a cup of hemlock. A man before his time, he dies. And Socrates says, I would rather die having spoken after my manner than to speak in your manner and live. That, friends, is the hallmark of a republic. That is the hallmark of democracy. And in a country today where we cannot speak our own mind, any country in the world, and our words are sought to be curtailed by offenses like sedition, that is not the indicator of democracy. There are many historical examples, whether it be in India, Tilak's Bal Gangadhar Tilak, Aurobindo Ghosh, or a few years ago, Kanhaiya Kumar, whose anti-national slogans caused him to be arrested. Let's look at the numbers for a moment. 2014, the National Crime Records Bureau says there are 47 cases of sedition reported, 30 in 2015. In 2018, the number increases to 70. Since 2016, only 5 or 6 sedition cases have led to a conviction in court. The fact is, as a nation, we are rather thick-skinned. Sorry, is the voice not audible?
You're fine. You're fine.
No, somebody sent a message. The voice is not audible. I can put the fan off in a minute if that's making an impact.
Sir, you are audible. I request the attendee to please check their internet connectivity.
Right. No, I got a message that my voice was not audible. The fact is,
thank you so much for addressing those comments, but I think, unfortunately, as we mentioned, technical glitches are always present. The majority of us can hear you clearly, so let's hope that's great.
Listen, we Punjabis tend to be very loud, so I got a little surprised when I was told that I was not audible. I'm not really a soft-spoken man, probably a problem to do with my lineage. But though my father was a soft-spoken man, being a Punjabi, but both my parents were, but I'm a slightly different cup of tea. So guys, the fact is that we are thin-skinned as a nation. For the most lightest of reasons, we take offense. So in January 2020, about 3,000 persons protesting against CAA are charged with sedition. The challenge on CAA is pending in court. There's a legitimate challenge. And therefore, I really don't see how sedition could be invoked. About 3,500 farmers charged with sedition for protesting about land disputes. In 2019, Manipur, a student is arrested. A Bengaluru journalism is charged for sedition for raising certain slogans. In 2020, a 22-year-old student activist at an LGBTQ event at Azad Maidan is arrested. And now in 2017, the NCRB introduces a new category of offenses. These are offenses against anti-national elements. Now, what are these anti-national elements? Northeast insurgents, jihadi terrorists, Naxalites, and other terrorists, and a total of 1,012 cases were registered in 2018. Sedition has an interesting history. It is brought into the penal code, the draft code, as clause 113. By mistake, it seems, I wish that mistake would have continued. Sedition was not kept in the draft of the penal code in 1860. In 1870, there was a movement thought of by the colonial government, which were said to be impacting law and order. So they bring in sedition. The Viceroy, Lord Mayo, and Justice Norman, Calcutta High Court, are murdered at about the same time. And then you bring in sedition with using of the word disaffection. The reason our colonial masters brought this in was because they wanted to restrain us natives, freedom fighters and nationalists, to prevent rebellion against the British Raj. Now, this was the original idea, because sedition really has a logic where there is a sovereign. In a democracy today, we are the sovereign. So there is no occasion to have offenses such as sedition. There are famous cases such as the Bangobasi case. I'm not going to get into that, where there was issues regarding the age of consent bill in Hindus, and it was a threat to Hindu religion. Then there's the Tilak case of 1898. He publishes 2 articles, he's prosecuted. And this led to a debate on the use of the word disaffection, which was central to sedition. And this was, what was disaffection? Hatred, enmity, dislike, hostility, contempt, and all forms of ill will. Well, if the government is not functional rightly, surely I can have a little contempt for their functionality. Tilak's case led to a lot of problems because disaffection and disapprobation were dealt with. There were various interpretations. And finally, this leads to a change in 1898. And the legislature now repeals it, brings in a new provision. There were famous trials post that, which was Mahatma Gandhi's trial. There was also the Annie Besant, Maulana Abdul Kalam Azad, and Sheikh Abdullah's trial, which happened post the 1898 amendment. There also came to be a difference in the 2 interpretations of the provision by the Federal Court and by the Privy Council. And finally, this matter went on, and the issue was overruled by the Sadashiv judgment of the Privy Council. So that was the pre-independence position. Post-independence, things change. We have a constitution which protects the right of freedom of speech, and sedition and public order do not find place mentioned. In fact, Pandit Nehru makes a very interesting speech in Parliament. He says, so far as I'm concerned, that particular section is highly objectionable and obnoxious. It should have no place both for practical and historical reasons, if you like, in any body of laws that we might pass. The sooner we get rid of it, the better. K. Munshi makes a speech saying public opinion has changed. We need to drop sedition. It's time that the word sedition should not be in the constitution. So usually Article 19(2 as libel, slander, defamation, contempt of court, etc. The validity of this provision then gets questioned. Ramesh Thapar, Tara Singh, Ramesh Thapar, 1950 Supreme Court, Tara Singh, and Ram Nandan. The matter finally reaches the need for a constitutional amendment, and through the first amendment to the Constitution, the additional grounds public order and relations with friendly states is added, and accordingly 124A now gets challenged, and in the classic decision of AR 1962 Supreme Court 955 Kedarnath Singh's, the Supreme Court lays down the interpretation of sedition, upholds it, but makes it very, very limited in its application. There must be an invocation to violence, is what the court says. But is that what is done today? The fact is, that is not the reality today. Every time a question is asked, every time a protest is raised, sedition is invoked for the weakest of cases, and this is happening across even the state governments. Even if you make a comment, in one case I was appearing for a newspaper which made a comment about the governor about his personal activities in Tamil Nadu, and sedition was invoked. Matter went to the Supreme Court. Finally, we succeeded, went back, and it got settled in the High Court. Therefore, my view is that despite this entire exercise of interpretative judicial creativity, it is time to really relook at sedition from the legislative point of view. And my view is that it is a law which is obsolete. It has outlived its use. It is no longer relevant in democratic India. It was brought in at a time when we had sovereigns, as I said. For those who rebelled against India, you had sedition. It has no place in modern India. And when the British have chosen to do away with it, surely it is time for us in a democracy, in a constitutional democracy, to rethink its application. Freedom of speech ought not to be allowed to be curtailed. Today, in an era when we have social media, the only use of sedition is to try and control certain aspects of free speech. But social media is not controllable, and that's something which we need to understand. And therefore, my view is, it is time for a legislative change. We need to ask Mr. Khurshid or his colleagues to try and move a private member's bill, if nothing else, hoping that this is finally brought to the notice of Parliament. I know Parliament has a lot of things to do. They're rather busy with more important things, but perhaps the citizens' rights are also require some consideration. There is within the IPC enough provision in Chapter 6, whether it be 121 to 30, 141 to 160. All of these deal with offenses against sedition, against public tranquility, law and order, violence. They will cover the gap. We do not need an offense of sedition. We all saw what happened in Section 66A of the IT Act in Shreya Singh's case. It was struck down. The Law Commission in 2018 issued a consultation paper asking about what should be done with sedition. Unfortunately, its term ended. I will only say this in conclusion. We are in our 75th year of Indian independence. Sedition cannot be used to assuage the hurt feelings of a few at the helm of affairs. The right to question our elected representatives is a fundamental right under the Constitution. It cannot be curtailed by abuse of state authority or police powers. It needs a legislative change. I must also hearken to add that the courts are seized with it in a matter which certain magazines in Andhra Pradesh, Justice Chandrachud's bench is dealing with it. But eventually the courts are going to interpret the contours of it. Can the interpretation be better than what was said in Kedarnath Singh? Perhaps yes, perhaps not. But interpretations have to be understood by the constable, by the sub-inspector, and by the inspector. Eventually, it is his understanding what constitutes sedition, not necessarily what the courts say. So it is time for a legislative change to protect democracy, to protect freedom of speech, to protect the right to assert one's thoughts in a changed world. Thank you very much.
Thank you, sir, for that very enlightening talk. I would say covering not just the history of the provision, but taking us right up to the present age, and for that very vocal and strong call to arms as well about how we can address or what is the next step in dealing with sedition. And on that note, I will like to then call upon our next speaker to see if he can answer that call to arms, as it were. And he's one who has never been shy of speaking on any topic. Certainly not one which he feels requires to be addressed. And on that note, I'd like to invite Mr. Khurshid to rejoin or to add his opinions on this topic.
Well, thank you, Mr. Khurshid. It sounds a little bit like an echo. Be that as it may, let me just say that it's wonderful to be here, and of course, my friend Siddharth Luthra, I couldn't have had better preface to anything that I have to say. His command on criminal law is remarkable, and the combination of the constitutional dimensions, etc., historically, I think he's wonderful. You would have had excitement if we disagreed, if we were on different sides as far as the dividing line may have been, but that's not the case, and that makes it a bit prosaic that we're both supporting, which is an outstanding and important cause, and we are both supporting it. But since the specific history and how the law has developed both in Europe, in England, from where we imbibed it and how we have dealt with it over the years, let me just say that it is comforting that very early on, when the government obviously was received greater trust from the Supreme Court, there was a national consensus on understanding of the Constitution and the steps that a new country was taking. And the Supreme Court, in that sense, did follow the government on many issues, though we know that the Supreme Court disagreed on issues that related to property rights. And that's a long saga that we don't have the time to go into right now. However, it did show a degree of trust as far as the law of sedition was concerned. What we are hoping, and what my friend Siddharth Luthra would inevitably argue, and I hope successfully, what we are hoping that the court in the present generation might do, if Parliament doesn't take up the challenge to repeal provisions relating to sedition, this court in the generation of Kedarnath Singh didn't go that far. It went quite far, but it didn't go far enough to say sedition cannot be part of the law of a constitutional democracy. Now, therefore, while we thank the court for having at least drawn some very clear red lines, but the surprising thing is that despite those red lines having been drawn, we are still today struggling with, and we are still trying to find a way around prosecutions that we hear and see every day. Siddharth is dealing with some. I had an interesting occasion barely 2 days ago, when the former governor of the state of Uttar Pradesh, which is my state, was was not charged yet, but had an FIR filed against him for having uttered something relating to a previous minister who is himself facing repeated prosecutions on different grounds, but in empathy or sympathy with that gentle person, having visited his house, the former governor of the state of UP said a few things that were somewhat colorful and somewhat extreme, but not in any way that one would have thought have anything to do with provocation, with violence, with saying or doing things. But these certainly were very strong words against the manner in which that former minister had been treated by the present government of Uttar Pradesh. So here was a former governor who has not just been a governor of Uttar Pradesh, but has been a governor of 2 other states, and now of course in retirement in Bhopal, who had an FIR filed against him for having said a few words against the government. There is not a word in the FIR as to how those words could have led to consequences unwholesome to the extent of justifying sedition under Section 124A. He was also charged with what really have become companion sections, Section 153A and 153B that Mr. Luthra talked about, which are other provisions that seek to make people accountable for uttering words that creates disaffection, that creates enmity, hatred, some degree of disquiet between different communities, etc. And there is a very, very callous and easy way in which any word uttered against anyone is treated as causing enmity between different communities, etc. So they are sort of companion provisions, and in this case that I just mentioned, 124A of sedition and 153A and 153B, which relates to causing enmity between different sections and different communities, etc., have been put into the FIR. Now, we still need to know, wait a while as to see what actually happens, and whether this would go further or it would subside and disappear gradually. So this is an issue, and what I instead of going back and repeating the actual evolution of the law as it's happened, in both in the favor of the citizen and otherwise, the surprising thing is that every day, and the figures were given by Siddharth, that every day there are these matters being filed, and certainly many of them were filed in the two or three protests that were indicated, the CAA, NRC protests that happened about 2 years ago, the protests that are happening now, including the protest of the farmers, and so on and so forth. That in all those, the sedition is used, sedition sections is being used. So it has been used in against media. If the media is overtly critical of the government, they are in real danger of having these provisions used against them. But to think that years after Kedarnath Singh, this continues to happen is a worrisome thing. That once the Supreme Court does definitively, conclusively state what their view is on the law, that it doesn't filter down to the policeman who has no reason at all to bring that provision into operation against any person, but goes ahead and does so. And then you have to go through the rigmarole of appearing in criminal courts and then challenging it in the High Court, and sometimes having to come all the way to the Supreme Court to finally get rid of that menace. Why does this happen? Now, I do believe that although the analysis Siddharth is given is perfect, and that analysis should, in due course, get us rid of this provision, I'm not quite sure that Parliament would do so. As a political party, we tried to toy with this idea in previous elections. We've tried to put it into the manifesto, but found that there was severe criticisms by the so-called self-appointed nationalists, severe criticism of this, and an attempt to merge and to bring together something that everybody would find offensive. People who indulge in acts of terrorism or virtual acts of terrorism, and people who are only critical of government. Merging those two together to file these cases against these people, including journalists, etc. But this happens because of unfortunate prevailing attitude, and I do hope that Siddharth will have a chance to comment on that. A prevailing attitude of what we consider to be the right of free speech, divorce and separately from these provisions. We as a country, we as a people, we as a culture have an issue with harsh language. We believe, we use this expression loosely about unparliamentary language. In politics, it's thrown at each other very, very frequently. But we don't really believe in what I have known some top thinkers of the world, particularly jurisprudence thinkers of the world, who believe in the right to ridicule. I think that our natural proclivity or our natural response and reaction is that you have a right to free speech, but the right to free speech does not include the right to ridicule. I know that this is a very contested area. I mean, I know that the Danish cartoons, for instance, and the French journal that published matters relating to religion, on that there was a very serious contested positions of people. Can you do this? Can you not do that? But of course, that got mixed up with religion a little bit, or largely. But if there is no issue of religion, and one reaches out to ridicule someone, that is still not accepted as justified or permissible. And therefore, anything that leads to ridicule will easily be pushed into the area of sedition or the area of causing enmity and so on and so forth. Same problem happens sometimes in defamation cases, that there are many defenses to defamation, but ridiculing somebody is perhaps something that would be on the edge. A court could go one way or the other. But that's an extremely important issue. The second important issue is, and I say that in the context of decisions that have been taken by the Supreme Court, particularly the suspension of 4G in Jammu and Kashmir, justified on grounds that 4G availability will help terrorists communicate with each other. There's no data to that effect. But in that context, Ronald Dworkin, who I admire greatly for his work in jurisprudence, once wrote a piece saying, and that was in the context of the Guantanamo detainees, that he said that if torture was permissible to get the truth about future prospects and future plans of terrorists, would you allow torture? Would a country that respects human dignity allow torture? And Dworkin, I guess, is amongst very few people who so frankly spoken and said, for one thing, we don't know that torture actually gets you to the truth. But the other thing is that to be able to get yourself a little more security, to torture a human being, is not just dishonoring his personality and abusing his dignity, but you're actually dishonoring your own personality and abusing your own dignity, because you're reducing yourself to less than an honorable person. So these are some ideas which are very provocative, which are perhaps very difficult to deal with in practical life, in real life. But there is not enough philosophical clarity on some of these issues in terms of what the ordinary person, the ordinary citizen thinks. So it's often, well, it's all very well to have freedom, but not freedom beyond that line which divides respect and ridiculing someone. Now, I believe that ridiculing someone, bad as it might be in terms of conduct and behavior and character, but ridiculing someone might be perhaps a right that we cannot ignore, because Dworkin says that if you feel very strongly about something, then you have to say it strongly. And I think that's something that colors the debate on between what the government's view today might be and some conservatives' view that might be, and that of the liberals, if you like, if I describe them that, as so that the difference is that they say that you may have the right to speak, but don't speak strongly, because that's not acceptable in our culture. Whereas a true liberal would say, if you feel strongly, you must speak strongly, unless, of course, it causes psychological and physical damage, where the other factors sort of take over. Now, we are today in a democracy, as Siddhartha said, and in a democracy, your right as an opposition, or being in opposition, or being even somebody who is neutral, your right to say the government is wrong, and to say it strongly, and to say it forcefully, and say it aggressively, is something that would demean and destroy democracy if that was considered to be prohibited. Because you're trying to change government, you're trying to oppose a government, but of course, it's clear, and I believe everyone would accept, that you can't use violence to remove government. But everything short of violence, surely, no matter how strong it is, and no matter how much ridicule it brings the government into, would have to be permissible. But that will depend on how Siddharth argues the case when it comes. So thank you very much, ladies and gentlemen.
Thank you, sir. Thank you, sir, for that. And as always, you challenged us to think about a question, not just in terms of the small questions, but in terms of the large questions. And we certainly applaud the very strong words that you have used on this topic, and all hope that the organizers and the speakers aren't called into questioning tomorrow on similar charges based on your encouragement.
You've got a good lawyer there. You've got a good lawyer there to appear for you, so don't you worry.
I've always said that if I ever get into trouble with speech, I have enough clients in prison, and maybe I'll make a few more, so I'm not too worried.
That's good. Yeah.
Right. So I'd like to take this opportunity to also introduce Mr. Ajit Mishra, who has also joined us. Ajit has been, I would say, instrumental in getting together the India chapter of the CCLS, and we certainly look to him as our leader and mentor of sorts. Ajit, thank you so much for joining us. I didn't want to interrupt the speakers before, but Ajit, of course, has been here for the conference as well, and thank you for joining us.
Thank you so much. Thank you so much. It was so enlightening as a topic. Mr. Khurshid and Mr. Luthra, thank you so much for coming and giving a kind of presentation on this topic, which indeed is something which we don't do on a usual basis. We don't think that aspect of society. which is quite important for us. So that's very enlightening. When Q&A session starts, probably I will have 1 or 2 questions to ask. So thank you so much. Yeah.
Yes, and on that note, we'll jump right into it. We actually do have quite a few questions from our various attendees in the chat.
Can I just make an observation about what Mr. Khurshid said, because if you don't mind, before we start.
Absolutely, sir. Of course, please.
Just to add one thing that, we've, Mr. Khurshid talked about the right to ridicule. I think it's a very important right. The problem that we face is, rightly or wrongly, criminal defamation has been upheld today. And there is civil defamation as well. There are issues about defamation, but let's leave that aside. One of the fundamental questions that we need to ask is, can you, if ridiculed, invoke the use of state authority or police agencies by invoking offenses such as sedition for individual anguish or individual hurt? And that seems to be the case across the board today. The second point that I want to make is, when we talk about, Mr. Khurshid made a very valid point, that we are talking about torture and a little more security. This seems to be the justification for torture, for what I term in India practical policing. When we were in Cambridge, we were taught a very interesting lesson that whenever police officers, even in that country, need to find a solution, they refer to the WNM Act. So I said, what is the WNM Act? I said, well, you need a warrant to search a house. So the solution that police officers would find was they would stand outside the house of a person, a suspect, and one would say, do you smell gas? And the other gentleman would say, yes, I do. And bang, they would break the glass and go and do a search. And if ever asked, they would say, well, we applied the WM Act, the Ways and Means Act. If you need to do something, you have the ways and means to do it. The third thing which I want to point out is, therefore, torture or third degree is a mechanism for, in effect, use or application of scientific policing. If the police are not trained to their job within the corners of the Constitution, they are going to resort to either third degree, torture, or practical policing. And we as a society, or any society, will end up condoning it for the sake of a little more security. But that does not democracy to a republic. The last aspect which I wanted to talk about was, Mr. Khurshid referred to the liberal and conservative view and the debate between the two and the digression between the two. But I would say that we also need to appreciate that there is a constitutional view, a fundamental rights approach. The right of an ordinary citizen to be left alone and to be able to express himself, and as he referred to Dworkin, in the strongest possible words. If I don't do that, I'm failing in my fundamental duty as a citizen, and the Constitution recognizes these fundamental duties. Therefore, I think it's time for us to rethink, and it's time for all of you young people here to rethink. If the government is not acting, if Parliament is not going to act, consider filing a challenge. I'll be happy to do it pro bono.
Splendid, splendid.
Yet another wonderful call to arms. With that, we'll take a few questions. We have, as I was mentioning, we have quite a few questions from our attendees. The first question, and some of these may have been covered by what our speakers have said, but I would invite either speaker to take the question if they would like to add any further comments. The first question, which is from one of our anonymous attendees, is that why do you think that the Indian government still holds on to this, what the speaker is calling an aggressive law inherited from the UK, when the UK themselves has done away with it? And I'll combine that with another question by one of our attendees, Ms. Urvi Gupta. Considering the present scenario and the recent activities of the present Indian government, how much legislative change do you think we can actually anticipate from this very government?
So would you like, is sir going to answer that? Or do I
Well,
go?
listen, I want to be about as fair as one can be in the absence of the other side. I believe that the government may well have a view that this is necessary for security of the country, and therefore they need it. But I believe that it's an imperative that they justify it, that they put out reasons for it that we can then respond to and say that's not justified. I believe a responsible government would want to further cut down the misuse of the provisions that we are talking about, even if they don't want to get rid of them entirely, because there is, of course, Siddharth said that there's a constitutional view, but the constitutional view, this whole business of constitutional morality, that all becomes subjective somewhat, relative somewhat, in the manner in which we look at the Constitution. And these are the challenges of years to come. There are a large number of people who have supported this government. It's come to power because of them. And therefore they resonate with the opinion then of those large number of people. And therefore the other view is a minority view, even if there is another view, because in fairness, this sedition remained right through my own government, the government of my party. It wasn't removed because people assumed that we were still not ready for it to be removed. So I'm just trying to be fair, but I believe the other side wouldn't have been if they had a chance to run me down on this. I'm just trying to be fair that I think we require a conversation about this, a conversation without rancor, without hatred, without fear, without ill will. We need a conversation. And I hope that you all would be able to encourage such a conversation at some future date. We can both come together to be fielded against two other people who think differently, if you can find them.
Can I add something?
Yeah, please.
So sedition laws over here in UK, I'm joining from London.
Right.
That was last prosecution that was done in 1972. And laws were abolished in 2009 and 2010. Since then, there has not been any debate about such law. When it comes to India, is problem law or how law has been used or misused, I will say? What's the real issue?
Siddharth, do you want to take that? I think it's a little bit of the latter, but let's Siddharth take that squarely.
I think after Kedarnath Singh, the application of sedition would have been well defined. But despite that, there has been an exploitation of the ambiguities in that judgment. There are some, and it leads to, there are few, not many, but it leads to a consistent misuse or misapplication of the law. Therefore, as I said, when there are other provisions in the penal code and other legislations which can deal with offenses against the state, it is perhaps necessary to curtail it, because till we curtail it, if we don't curtail it, and the fact is Mr. Khurshid is very right, irrespective of which government has been at the helm of the affairs, they've continued to use it. And governments in the last 75 years have used it consistently. Nobody's done away with it. In fact, the First Amendment was brought to justify sedition. Having said that, I think it'll require legislative change. Yes, the other side is not here. They have their own justification for it. But it surely cannot be used to assuage bruised egos. And that seems to be the application more often than not. If there is violence as a consequence of the free speech, perhaps that's the area, that's what Kedarnath Singh permitted, but not just free speech or speech which is offensive to an individual. For that, you have defamation laws.
Yeah. Thank you so much. Thank you.
Thank you, Mr. Luthra. Thank you, Ajit, for your question. We have Mr. Rajendra Dijpali, who's joining us all the way from the United States. He's a member of the Gandhian Society. And Mr. Dijpali, please, you have the floor. Please unmute yourself. Okay. Okay. While Mr. Dijpali is attempting to unmute himself, there's a question from one of our attendees, Mr. Abdul Hanan Kirmani. He asks, how would you see the recent Jammu and Kashmir government order threatening to terminate employees if they are found to have sympathy with people who commit or attempt to commit or aid or abet, among other acts of sedition?
Well, government
Well,
employees.
I'm sure both of us have something to say about this. These are difficult matters, because there is a context. You know, it is not just simply anything, anywhere, any person. There's a context, a very complicated context of Jammu and Kashmir, but I think this is still excessive. I think it's still going too far. I just want to quote what the Delhi High Court had said in the NRC matter. He said a speech, no matter how forceful, made by a college student is not going to shake the foundations of this country. Now we should believe that the foundations of this country and the foundation of our systems are a lot more robust and a lot more lasting and sustainable than would be impacted adversely by a statement that is made, or a sympathy or an adverse attitude that's taken towards. But this is subject to, as I said, some very special conditions.
Secretary of our Maharashtra Pradesh Committee, and she is also running a lot of initiatives, for the minorities, and then she is also associated with many.
Salmanji.
Mr. Dijpali, yes, Mr. Dijpali, please. You wish to join the conversation. Oh gosh, and as always,
he's muted. He's still muted.
Yes.
He's put his hand up, but he's muted.
Yes, I think as always.
Yeah. Can you hear me? Can you hear me now?
Yes, Mr. Dijpali, we can hear you. Please.
Good evening, Salmanji and team. It's an honor and pleasure to be. Thank you so much, Jafar, for inviting me to this event. First of all, as Salmanji has rightly said, we need to all come together right now and protect the very idea of India that is being threatened, and the lot of forces that are working on this have to be stopped. And I think if we do not do this at this time, we will forever lose the whole idea of India that was built over decades. We are seeing so many institutions that were built meticulously crumbling and being given away to private sectors. I do not know whether this will work out or no in the long run, but I do think that we have to all unite together and work together. And the time has come now to aggressively take on these forces that are threatening the idea of India. And I look forward to working with the team and Salmanji and others. Thank you so much for this opportunity, Jafar. And as always, it's a pleasure to interact with Salmanji and others. Thank you.
Thank you, Mr. Dijpali. And I think that we should all take solace that if like-minded Indians can unite from across the seas, from the UK and India and the US, then surely we can all try and unite here within our shores as well. The next question, again, I would, if both the speakers could give their perspective on this, because I think that they may have their own unique perspectives. Can 124A be struck down in silo? Would the strike down also not involve substantial changes to the IPC and possibly even a constitutional amendment specifically protecting free speech? Now, of course, we have a former Minister of Law and a former ASG who would be on both ends of a new have the experience of being on both ends of a new law, passing it and defending it. So if you could please give us your perspectives on this.
Well, I was very well advised by the additional Solicitor General, and I would have taken his advice in this matter as well. But since we are neither in office, neither of us is in office anymore, let's just take virtual advice from him and then stick to that advice.
Thank you, sir. I would only say this, that we have a five judges the Constitution bench of 5 judges, which has upheld the law. There is a 3 judges bench which is considering the matter. So unless we can get it sent to 5 and then perhaps to a larger bench to reconsider the view in Kedarnath Singh, we do not expect any immediate results from court, because there is a Constitution bench of 5 judges which has upheld the validity of the law. The other alternate path, of course, would be to be a legislative amendment, and that, as we know, it doesn't seem to be likely to happen. We've seen it for the last 75 years. So right now, I think the most effective remedy is in court. My view is that we need to do away with this. Reading it down may not be the answer any longer. There cannot be a further, I mean, I think the restriction Kedarnath Singh is, with its little ambiguities, is fairly clear. You can't restrict it still further. And I don't see any court easily doing that. So it'll have to be a full-on challenge.
Right. If any of the other organizing committee doesn't have a question, I'd like to raise one to the speakers here. So you both mentioned this. I think from different perspectives, you mentioned that a part of the problem seems to be that we are not so thick-skinned, or that rather our government is not so thick-skinned. And do you think that this is necessarily always been the tradition, or is it something to do with how the current government perceives criticism? Because we have had in the past for courts, but not in the context of sedition, but for example, in the context of defamation or in the context of open criticism, say that, and I know that Mr. Khurshid himself would be very familiar, that those in power have to be open to criticism, have to be happy to invite it. We have had judges in the past who've given such indications. So is this a trend? Is this a trend that has come out of this current government, or is it a trend that we are seeing more often because maybe the average populace is feeling more empowered to criticize openly?
Well, I think it's both ways. I mean, it's not just a matter of incumbent government. I think it's a political culture that you develop and evolve over a period. The same thing, I believe we both would feel the same way about how judges treat contempt of court. There are some judges who follow the British attitude of, that you're calling us fools, so it's not going to make us fools. And there are judges who would say, I don't like that, I don't like the look on your face, etc. And I will drag you to contempt on this. So there are judges and there are judges, there are governments and there are governments, there are ministers and ministers. And therefore you cannot just put them all in the same straitjacket. You just have to look at each one separately, and then find your way around that person, or then find your way of taking the bull by the horns. Now, it depends also a lot on the attitude of the litigant and the attitude of the lawyer that the litigant has engaged.
So my view would be, and I concur with what Mr. Khurshid has said, it's a very individual outlook. Unfortunately, there is not we can't just attribute it to one administration or the other. The fact is that there are periods in our years as a society, in our life as a society, where we are more open to free speech. And there are periods where a more conservative view tends to hold, tends to be more acceptable, or tends to hold sway. At this point, what becomes very crucial is the outlook of the courts and the outlook of the media. And wherever governments of the day, and this has happened over the last many decades, have been constricting free speech, I think it's the duty of media, it's the duty of the courts and the duty of citizens to speak up. It is not enough for us to not deal with this issue publicly and vociferously, though within the corners of the law. Because if we fail to do that, we are really allowing majoritarianism to succeed. And there always has to be an alternate view. The fact is, a lot of us lament, and I speak here as a citizen, that we do not have enough in an alternate view that is being voiced, barring some strong, sane, mature voices like Mr. Khurshid and others. And it is those voices that need to stand out, and we need to support those voices to ensure a fairer and a better society.
I think that is a wonderful note on which we can conclude today's webinar. I would, on behalf of the entire organizing committee of the CCLS India chapter, I would like once again to thank our two distinguished speakers. Thank you for taking out the time. Thank you for really speaking to us frankly, speaking to us strongly, and I think giving all of us some real big and small questions to ponder as we go forward in as legal practitioners, as citizens. Thank you, everyone. Thank you to the speakers. Thank you, Krishan and Ajit, Abhishek. Thank you to all of our participants. It has been a wonderful session, and I hope that we'll get to see most of you, if not all of you, again very soon. With that, we will conclude, and yeah, thank you very much.
Thank you so much. Thank you.
Okay, bye. Bye.
Thank you so much. Thank you, sir. Thank you, everyone.
Bye. All the best. Good luck. Thank you.
Bye.